Hello everyone, this is Peter Poon from eLaw Alliance. I have with me today Janan Jera. We're going to be talking about family law procedures, more specifically for the Court of Queen's Bench in Alberta. There's two courts that you can go and apply for your parenting matters, your child support matters in Alberta. We're going to try to answer some of the questions today and to kind of help you figure out which court is more appropriate for you, and you can make your decision there. Certainly, this is not a video for as a legal advice. If you want more tailored and specific legal advice to your circumstances, please give us a call. Janan, we'll start off with what is the difference between Provincial Court and Court of Queen's Bench in Alberta?
So in terms of family law, the provincial courts and the Court of Queen's Bench, there is a ton of overlap. For example, both the provincial court and the Court of Queen's Bench can deal with child support matters. They can both deal with parenting matters. They can both deal with spousal support matters. But where it gets more divergent is with regards to divorce and division of marital property matters. The provincial court does not deal with divorce. You can't be granted a divorce in provincial court. That's something that you can only have obtained through the Court of Queen's Bench. In addition to that, marital property claims are normally under the Divorce Act, and that is something that has to be dealt with in the Court of Queen's Bench as well. Now, there are changes either in place or about to be placed where the laws regarding division of property are going to be less different in a marriage context than in a common law context. But that aside, to deal with division of property matters as related to a divorce, you deal with it in the Court of Queen's Bench.
And maybe kind of go over with us what are the legislations, the main ones surrounding family law here in Alberta.
So I'd say the two main legislations are the Divorce Act, which is a federal piece of legislation, covers all of Canada, and then also the Provincial Family Law Act. The difference between the two, and there are less of a difference now, there are laws coming into play that make it so that if you're in a common law scenario versus a marriage scenario, they used to be very different, but now they're not so different. The rules overlap, and the rules generally apply to if you're in a marriage versus if you're common law. But the Divorce Act and the Family Law Act of Alberta are the two acts that you're going to run into if you have a family law matter you're taking to court.
And just from that, what if I have a parenting matter and if I'm still married to my spouse, can I still go through and make an application in provincial court?
Absolutely, you have the choice. As I said before, both the provincial courts and the Court of Queen's Bench deal with parenting matters. So it really is your choice of where you choose to commence a parenting application, whether through the provincial courts or through the Court of Queen's Bench. If you're going through the Court of Queen's Bench, there is a requirement that you have to complete the Parenting After Separation course. It's an online course, it's free. It's great as far as providing information on how parents should deal with the issue of parenting in best interest of the child. And it is mandatory that you complete that program or that course before you're even allowed to file a family law application or even a divorce application through the Court of Queen's Bench. There are some exceptions to having to complete parenting after separation. For example, I've been able to get exceptions for people who don't speak English, and so far the course is only offered in English, so you can obtain an exemption in that kind of scenario. So there are a few exemptions to the parenting after separation course, but for the most part it is a requirement. You have to complete it, show proof of completion before you're allowed to bring your parenting matter through to the Court of Queen's Bench.
You talked a little bit about the differences between provincial court and the Court of Queen's Bench for family matters. Are there any advantages or disadvantages for each of these courts when I'm making my application and that I should be aware of?
In my experience, and I've done litigation and appeared in both the provincial family courts and the Court of Queen's Bench family courts, and there are differences in terms of procedure, process. Some of the requirements are a little different, but overall they are generally the same, meaning you're in a courtroom being presided over by a judge, and the judge will require you to either let him know or her know what your agreement is, or if there isn't an agreement, that judge is going to decide for you in terms of what the issues are. So I wouldn't say there's an advantage one over the other. They both offer the same things, even in terms of assistance for self-represented individuals. If you're self-represented in provincial court, there's duty counsel. If you're self-represented in Court of Queen's Bench, there's also duty counsel. A free lawyer at the courthouse that helps you with matters that when you don't have your own lawyer.
And Jeanette, one of the documents that we always get clients asking us about is an affidavit. The court's always asking, is it in an affidavit? What exactly is an affidavit?
Sure. So an affidavit forms part of your application, part of the paperwork you need to file at the courthouse to get your matter on the list. So normally it starts off with some sort of application which summarizes what your claim is for. For example, your claim could summarize you want child support and parenting. What often accompanies the claim or the application, the summary of the matters, is the affidavit. So the affidavit is a sworn document. It basically, in your own words, it has to be true, it has to be factual, based on facts, and it is basically what you would tell the judge if you were standing in front of him or her telling them your story, except you're putting it in the form of a written document. That's what an affidavit is. It's sworn, it is supposed to be entered into the court record, and it serves as your basis for claim.
The other document that we always get asked by our clients, Jeanette, is disclosure or request for financial documents. What exactly does that mean, and why would we need it?
So when it comes to, especially when you're trying to figure out child support matters or division of property matters, exchange of disclosure is mandatory, it's a requirement. What it entails is both sides are obligated to exchange with each other their income information. For example, if you are an employee, you'll be required to give the other side usually about 3 years worth of your notices of assessment. Part of the disclosure could also include bank statements. It could include credit card statements, loan statements, any statements that relate to income is part of the disclosure. And the reason why you exchange disclosure in child support matters or division of property matters is just so that you, the other side, and the courts can be transparent about the information, so that any child support that is set in place is based on a correct income. We can't figure out income unless we do the exchange of disclosure, of financial disclosure.
So, Jeanette, walk me through the procedure. Now that I have drafted my application, my affidavit, all of the documents that I need to start my application, where do I go from here?
So if you've got all of your documents ready to go, so your application or claim, your affidavit, any supporting documents like the parenting after separation certificate, you take that package of information and then you have to file it at the courthouse. If you choose to file in provincial court, there's a different area of the courthouse in Edmonton where you would file that. If you're filing the Court of Queen's Bench, also a different counter area to file that. And there is a filing fee at the Court of Queen's Bench, so that it does cost money to file any sort of claim. However, if you are on legal aid, as long as you present a legal aid certificate to the counter, they'll waive those fees. But if you're not on a legal aid retainer, expect that you will have to pay some money to file your claim.
So I've filed my claim now. I've gone to the counter to Court of Queen's Bench to file my application and claim and all my documents. The court has put a stamp on it. What should I do now?
So once the court has put a stamp on it, the next step is crucial. The next step is that you have to make sure you, or if you've hired a lawyer, your lawyer will ensure this, you serve the other side with notice of your application. If you don't properly serve the other side with notice of your application and prove that you've done so through what we call an affidavit of service, the court isn't even going to listen or hear your matter. You have to be able to prove that the other side, the other person, received a copy, and that's usually done through a document called an affidavit of service.
And who should I go ask for to serve this document? Do I just hand it to them, or are there rules about that as well?
There are rules. For example, if you're filing a commencing document for a divorce, it's called a statement of claim for divorce, there are specific rules. You're not allowed to serve the other side personally. You actually have to get somebody else to serve that person personally for you. If you're just filing for parenting application or a child support application, you can serve the other person. You are permitted to do that, but in each case, you have to prove service through a document called an affidavit of service, where you're basically swearing that on such and such date at such and such time, you provided the other party with the list of the documents, including the claim and the affidavit.
So this is the time when they have received my application, and there will be a court date on it, so they'll know when to go to court next.
Right. So when you file the documents, for example, at the Court of Queen's Bench, when you file, you'll also be given a court date. And give yourself enough time for the court date to be able to serve the other side, so that you're not running into troubles on your first court date if you haven't given the other side enough time to serve. And if I'm not mistaken, it's the deadlines for service, if I'm not mistaken, are 30 days if somebody is out of the country, and I believe it's 20 days or less for someone inside the country. You can bring motions to court or applications on emergency basis as well. It isn't just a strict timeline, but generally you do have to give people a few days to respond to your application before you bring it into court.
I see. I think that's all the time that we have for today. On the next video, we'll go over a little bit of what you can expect once you have the matter into court. Thank you very much, Jeanette. And again, give us a call if you have any questions.